act has already happened, withdrawal generally only limits liability for future substantive crimes, similar to common law.
Okay, majority federal. Withdraw before overt act to maybe beat the conspiracy charge.
And the Model Penal Code has perhaps the strictest standard for withdrawal from conspiracy. Withdrawal is possible only if the defendant acts voluntarily to thwart the success of the conspiracy.
Thwart it, like actively stop it.
Yes. It requires an affirmative action to prevent the crime from happening, persuading others to abandon it, going to the police in time to stop it.
Yeah.
Simply walking away isn't enough under the MPC. It's a very high standard, reflecting the danger of group crime.
Wow. Withdrawal is complex and jurisdiction dependent.
Very much so. Finally, the last, inchoate crime, attempt. This is the closest you get without crossing the finish line of the main crime. It's when a defendant goes far enough down the path, but the crime isn't completed. An attempt requires two key things. First, the defendant must take a substantial step toward the commission of the intended crime, a step that goes beyond mere preparation. Second, this step must be coupled with the specific intent to commit the underlying target crime.
Substantial step plus specific intent. What counts as a substantial step? That sounds subjective.
It can be. The Model Penal Code, which represents the majority rule on attempt, uses this substantial step test. It means the defendant's conduct must be strongly corroborative of their criminal purpose. Examples might include lying in wait for the victim, possessing materials specially designed for the crime near the scene, casing the location, soliciting an innocent agent to commit an element. It's more than just thinking or planning, it's starting to do.
Okay, substantial step MPC majority. Is there another test?
Yes, the older common law approach, now the minority rule, uses the much stricter dangerous proximity test. Under this test, an attempt doesn't occur unless the defendant comes dangerously close to actually completing the crime. They have to be almost at the point of no return, doing the last act necessary before completion.
Dangerously close. That sounds much harder to meet than substantial step.
It generally is. The MPC's substantial step test allows police to intervene earlier once someone has taken significant actions demonstrating their criminal intent. Exactly. The defendant intended to commit larceny, took the step of reaching into the pocket, but factually couldn't complete it because there was no money. They are still guilty of attempted larceny because their intent and actions demonstrated their criminal purpose. The law punishes the attempt, even as circumstances made completion impossible.
Factual impossibility equals no defense. What's the other kind?
The other kind is legal impossibility, and this is generally a valid defense to attempt. Legal impossibility occurs when the act the defendant intends to commit is simply not a crime under the law, even if the defendant mistakenly believes it is.
So they try to do something they think is illegal, but it's actually perfectly legal.
Precisely. If you attempt to receive stolen goods, but unbeknownst to you, the goods have already been recovered by the police and are no longer considered stolen, you can't be guilty of attempted receipt of stolen property because the act you intended, receiving property that is legally stolen, was legally impossible under those facts. You intended something, but that something wasn't a crime.
Factual, no defense. Legal, yes, defense. That's a crucial distinction.
Absolutely. And the other significant potential defense to attempt is abandonment or renunciation.
Can you back out of an attempt?
Again, it depends on the jurisdiction. Under the majority and common law rule, once the defendant has taken the substantial step, or reached dangerous proximity, completing the actus reus for the attempt, abandonment is not a defense. You've already committed the crime of attempt by going that far.
So majority common law, once you take the step, you can't unring the bell.
Generally, no. However, under the minority and model penal code rule, voluntary abandonment is a defense to attempt. If a defendant voluntarily and completely renounces their criminal purpose before the crime is completed, they may be able to avoid conviction for attempt.
Voluntary abandonment works under MPC minority. What does voluntary mean here?
Voluntary is critical. It means the abandonment must stem from a genuine change of heart, an internal decision to give up the criminal endeavor. If the defendant abandons because they get scared of being caught or because unexpected difficulties arise, like the victim puts up a strong fight or a police car drives by, that's generally not considered voluntary abandonment. It has to come from within, not from external pressures or increased risk.
Another MPC rule providing an exit ramp, but only for genuine changes of heart.
Exactly.
Okay, we've covered the core principles, homicide, other crimes, and inchoate offenses. Now let's pivot in Chapter 5 to focus solely on the various defenses that can mitigate or excuse criminal liability entirely. We've touched on some already, like mistake and intoxication, but let's consolidate and explore others.
Absolutely. Understanding defenses is just as crucial as understanding the elements of the crimes themselves. As we discussed earlier, mistake of fact can be a defense. To quickly recap, it's a viable defense if the mistake is reasonable, considering the defendant's characteristics, experiences, knowledge, and negates the required mental state. An unreasonable mistake is generally only a defense to specific intent crimes.
Right. And mistake of law is rarely a defense.
Correct. Now let's talk about justification defenses, starting with self-defense. When can you legally use force to protect yourself, and how much force is acceptable? The general rule for self-defense is that a person who is not the initial aggressor is justified in using reasonable force against another person when they reasonably believe that such force is necessary to prevent immediate unlawful harm to themselves.
Not the aggressor, reasonable force, reasonable belief, immediate harm, lots of conditions.
Yes, the key is reasonable force. You may only use as much force as is reasonably necessary to repel the attack, no more. Proportionality matters.
So you can't use deadly force against a minor shove.
Generally, no. Deadly force has stricter rules. It may only be used in self-defense if the person reasonably believes that deadly force is necessary to prevent either 1. Imminent death or serious bodily injury to themselves, or 2. The commission of a serious felony involving a risk to human life, like robbery or rape.
Only against deadly threats or serious felonies. What about the duty to retreat? Do you have to run away if you can before using deadly force?
This is a major point of division between jurisdictions. There is generally no duty to retreat before using non-deadly force, but for deadly force.
Yeah.
The majority view in the U.S. is that retreat is not required, even if it can be done safely. You can stand your ground and use deadly force if justified.
Stand your ground. That's the majority.
Yes. However, the minority view does impose a duty to retreat before using deadly force if retreat can be accomplished with complete safety. If you can safely escape, you must do so rather than use deadly force.
So minority rule requires retreat if safe. Is there an exception?
Yes. A near-universal exception to the duty to retreat, even in minority jurisdictions, is the castle doctrine. Retreat is never required if the person is in their own home when they use deadly force in self-defense. Your home is your castle. You don't have to flee from it.
Castle doctrine, no retreat needed at home. Good to know. On the bar exam, how should we handle retreat?
They will usually specify if a duty to retreat applies in the fact pattern. If they don't specify, you should generally assume the majority stand your ground rule applies, meaning deadly force can resist deadly force without retreat unless you're told otherwise.
Okay. What if you started the fight, the initial aggressor rule? Can you ever claim self-defense then?
Generally, an initial aggressor cannot claim self-defense. However, an initial aggressor can regain the right to act in self-defense in two specific situations. First, if the aggressor used non-deadly force and the victim responded with disproportionate deadly force. The victim's escalation gives the initial aggressor back the right to defend against that deadly force.
So if you shove someone and they pull a gun, you might be able to defend yourself then.
Potentially, yes. Second, the aggressor can regain the right if they, in good faith, completely withdraw from the altercation and clearly communicate that withdrawal to the victim. But the victim continues the attack anyway.
So effectively, try to stop the fight you started.
Right. If you clearly back off and the other person keeps coming, you might regain your right to self-defense.
Okay. How about defending other people? Defense of others?
The right to defense of others generally mirrors self-defense. You can use the same level of force, reasonable and deadly, only if justified, to protect another person from immediate unlawful harm as you could use to protect yourself, provided that the person you were defending would have had the right to use that same force in self-defense themselves.
So you step into their shoes legally.
Exactly. If they weren't justified in using force, you generally aren't either when defending them.
Makes sense. Now, what about defending your stuff? Defense of property. You mentioned those booby trap stories. I assume the rules are strict here.
Extremely strict, especially regarding deadly force. For non-deadly force, a person may use reasonable efforts, including reasonable non-deadly force, to protect their real or personal property from unlawful interference when they reasonably believe force is necessary and there's no time to resort to law enforcement.
Reasonable non-deadly force to stop trespass or theft happening right now.
Right. But the force must be proportionate. Now, deadly force, this is critical. Deadly force generally cannot be used solely to defend property.
Cannot use deadly force just for property.
Correct. The law values human life far above property rights. There's a narrow exception. Deadly force might be permissible to prevent a forcible entry into a dwelling if the occupant reasonably believes the intruder intends to commit a felony inside, posing a threat to persons within. But you cannot use deadly force simply to stop someone from stealing your TV from your lawn, for example.
And those booby traps.
Absolutely not appropriate. Using mechanical devices like spring guns or traps designed to inflict deadly force to protect property in the owner's absence is generally illegal and can lead to homicide charges if someone is killed or injured. You can't use deadly force indirectly when you couldn't use it directly if you were present.
Life over property. Clear rule. Okay, what about force used during an arrest?
The rules differ for police and the person being arrested. Police force. Police officers are privileged to use the amount of force reasonably necessary to effectuate a lawful arrest. However, deadly force is only permissible if the officer reasonably believes the suspect poses a significant threat of death or serious physical injury to the officer or others. They can't use deadly force simply to stop a fleeing felon who poses no immediate danger.
Reasonable force for arrest, deadly force only if suspect is dangerous. What about the person being arrested? Can they resist?
Defendant resistance. A person may use non-deadly force to resist an unlawful arrest, an arrest made without probable cause or proper authority. However, deadly force is never allowed to resist an arrest, even an unlawful one. The policy is to challenge unlawful arrests in court, not through violence.
Non-deadly force okay for unlawful arrest, deadly force never okay. Got it. Now, what if you're forced to commit a crime? Duress.
Duress is an excuse defense. It applies when a third party's unlawful threat causes the defendant to reasonably believe that the only way to avoid imminent death or serious bodily injury to themselves or another innocent person is to violate the law. Indeed, that threat actually causes the defendant to commit the crime.
Coercion by serious threat. Do this crime or else.
Exactly. It's about being forced into it under extreme pressure. However, there's a very significant limitation. Duress is generally not a defense to intentional murder.
Can't kill an innocent person under duress.
The law generally won't allow you to choose to kill an innocent third party to save yourself or someone else from a threat. That choice is deemed unacceptable. However, duress can potentially be a defense to the underlying felony in a felony murder charge. If you were forced under duress to commit the robbery, you might avoid the robbery conviction and therefore also avoid the felony murder conviction that stems from it.
So can't excuse murder itself, but might excuse the felony leading to felony murder. Interesting.
It is. And finally, the last major justification defense, necessity. This is sometimes called the choice of evils defense.
Necessity.
Yeah.
This is when forces of nature push you into a crime, not a person threatening you.
That's the key difference from duress. Necessity applies when forces of nature, like a storm, fire, earthquake, or other physical circumstances beyond the defendant's control, cause the defendant to commit an act that would otherwise be a crime in order to avoid a greater harm.
Like breaking into a cabin during a blizzard to survive.
That's the classic example. You commit trespass and breaking and entering, lesser evils, to avoid freezing to death, the greater harm. The defendant must reasonably believe their action is necessary to avert the imminent greater harm, and there must be no reasonably apparent, adequate, non-criminal alternative.
No other choice but the crime. Are there limits?
Yes. Necessity is generally not a defense if the defendant themselves substantially contributed to creating the emergency situation, like recklessly starting the fire they now flee. Also, like duress, necessity is typically not a defense to homicide. You generally can't choose to kill one innocent person to save others, although this is a point of intense philosophical debate.
Duress, human threat. Necessity, natural situational threat. Both generally no defense to homicide.
Got it.
You've got the core defenses down.
Okay. Chapter 6. Summary. We've covered a massive amount of ground. How do we bring this all together, especially for someone trying to spot issues quickly, like on the bar exam? You called it the bar exam playbook earlier. Exactly. To synthesize all this for tackling essays or multiple choice questions, here's a systematic way to think like a legal pro and spot the key criminal law issues immediately when you read a fact pattern.
This is the checklist, the ultimate cheat sheet for navigating any criminal law scenario. Let's run through it. Step 1.
Step 1. A. What was the harm? Categorize the potential crime based on the result or conduct. This immediately narrows your focus.
Okay, categorize the harm. Like,
Was the harm primarily to property?
Yeah.
If so, immediately think larceny, larceny by trick, forgery, embezzlement, false pretenses, robbery, extortion, burglary, arson, possession offenses, receipt of stolen property. Run through those mental checklists.
okay, property crimes. What if the harm was to a person, but not death?
Then your mind should jump to battery, assault, mayhem, kidnapping, false imprisonment, rape, which we didn't detail but falls here.
Person crimes, non-homicide. What if there was a death?
Death triggers the homicide analysis. Was it common law murder? With malice. Felony murder, statutory murder, first or second degree, voluntary manslaughter, mitigated, or involuntary manslaughter, unintentional.
Homicide analysis? And what if the crime wasn't finished?
Then you're in the inchoate category. Think about merger rules, solicitation, conspiracy, and attempt. Categorizing the harm first directs your entire analysis.
Great first step. What's step 2?
Step 2, B, what mental state was required? Once you have a potential crime, immediately identify the mens rea. This is often the most crucial analytical step.
Identify the mens rea, so ask.
Was it a specific intent crime? FI8 list. First-degree murder, inchoate, assault, bump offenses, theft offenses. Remember, specific defenses apply here.
Just specific intent.
Or is it a malice crime, common law murder, arson? Remember the reckless disregard standard?
Alice or...
Or is it a general intent crime, battery, rape, kidnapping, false imprisonment? Remember, transferred intent might apply here. Just need intent to do the act.
General intent or under the MPC.
Is the model penal code applicable? Now then analyze. Purposely, knowingly, recklessly, or negligently. Match the facts to the MPC hierarchy.
PKRN. And don't forget...
Strict liability. Did the statute clearly dispense with mens rea? Statutory rape, bigamy, regulatory offenses? If so, mental state is irrelevant. Nailing the required mental state is absolutely critical.
Categorize harm. Identify mens rea. What's the final step?
Step 3. C. Do any defenses apply? Run through the checklist of potential defenses based on the facts and the crime identified.
Check for defenses, like...
Mistake of fact. Was it reasonable for general intent malice? Or unreasonable? Okay, for specific intent. Did it negate the MPC state of mind? Mistake of law. Generally no defense unless maybe MPC exception applies.
Mistakes, then capacity.
Insanity. Which test applies? Igniting, irresistible impulse, Durham, MPC. Apply the facts to the relevant test. Intoxication. Was it voluntary? Defense only to specific intent if negates intent. Or involuntary, broader defense. Immaturity, infancy. Check the age rule.
Capacity defenses, then justification excuse.
Defense of self or others. Was the force reasonable? Was deadly force justified? Duty to retreat applicable. Aggressor issues. Defense of property. Was force reasonable, proportionate, non-deadly? Deadly force very limited. Arrest. Police force versus defendant resistance rules. Duress. Threat of imminent death, serious injury. No defense to murder. Necessity. Choice of evils due to natural forces. No defense to murder. Systematically checking these defenses against the facts ensures you don't miss key issues.
Harm, mens rea, defenses. That 3-step process seems like a really solid way to attack any criminal law question.
It provides a structure, a way to organize your thoughts under pressure, and make sure you cover the essential elements and potential counterarguments.
We've just taken a really deep dive into the fundamental principles of criminal law. We've laid out the core elements, distinguished the various types of crimes, and explored those critical defenses. Hopefully, this gives you a much clearer framework for understanding criminal culpability.
Absolutely. And remember, understanding these concepts isn't just about rote memorization for an exam, although that's part of it. It's really about developing a systematic framework for critical thinking, for legal reasoning. This information allows you to approach complex legal problems methodically, seeing the connections and identifying those subtle nuances that can completely change the outcome. It's about learning how to apply the law, not just reciting rules.
So what does this all mean for you, our listener, as you continue your studies or just try to understand the legal world? Now that you have this robust framework, consider a hypothetical. Think back to that bystander who witnesses a serious assault but doesn't intervene. Using the principles we discussed today, specifically actus reus and the duty to act, what elements would you scrutinize? What questions would you ask to determine if any criminal liability could possibly arise from that omission? Where are the potential legal hooks, or why might there be none?
Or take another example. When a defendant claims they acted out of necessity, say, they broke into a pharmacy to get life-saving medicine during a natural disaster. How would you dissect that claim using the specific limitations we covered? What facts would support the defense? What facts would undermine it based on the requirements of no reasonable alternative? Avoiding a greater harm and not causing the emergency yourself. The power of this knowledge is truly in its application.
Keep asking why and how. Test these concepts against different fact patterns.
Yeah.
Push the boundaries. That's how you move from just being informed to being truly insightful.
Remember, in criminal law, perhaps more than anywhere else, every detail matters, every element, every potential defense. And critical thinking, that ability to systematically analyze and apply these rules, is your most essential tool.
Thank you so much for joining us on this deep dive into criminal law. Until next time, keep digging, keep questioning, and keep learning.